Welcome to the Deep Dive. Today we're plunging into a topic that, well, it affects every single one of us. How law is desperately trying to keep pace with a world that's changing at lightning speed.
It really is.
Think about it. New technologies popping up constantly, global issues demanding global responses. Can our legal systems really keep up?
That's the million-dollar question, isn't it?
Yeah. This deep dive is all about the incredibly dynamic landscape of modern law and how it's struggling, adapting, and transforming under the immense pressure of rapid technological change and globalization.
We've got quite a stack of sources lined up.
We do. We're looking at legal trends in data privacy, AI, the complex world of copyright, climate legislation, even core administrative law shifts in the U.S.
Quite a range.
Our mission today is really to cut through that complexity, give you the essential nuggets of knowledge, help you understand how legal systems are trying to catch up, why it matters to you, and maybe where the next big legal battles might emerge.
Exactly. And I think a great place to start is that AI and data privacy frontier, because this is where you really see existing laws grappling with completely new challenges.
Makes sense.
Technology, for all its amazing possibilities, it really is a double-edged sword when it comes to legal rights. We saw this unfold with the early internet, didn't we?
We did.
And we're seeing it again right now with generative AI.
That's a great place to start.
Yeah.
Because the law often responds by creating these compromises.
Yeah.
And they don't always hold up over time. A classic example is safe harbor provisions.
Yes. Safe harbor.
Introduced way back to deal with copyright online.
So safe harbor, put simply, it's basically a legal exemption for online platforms, think YouTube, places like that, from being held responsible for copyright infringement.
Okay.
The idea was, look, if they didn't know about the infringing material, or if they acted swiftly to, take down content once a right shoulder notified them, they wouldn't be liable.
Sounds practical on the surface, right?
Yeah.
A way to let the internet grow quickly without stifling innovation.
It certainly seemed like it. It was presented as this big compromise. It shifted enforcement away from the courts to more of a private enforcement model.
Right.
And the justification was, well, this allows for rapid and efficient technological growth.
But when you dive deeper into this solution, it gets interesting. It actually diluted copyright protection in some pretty counterintuitive ways.
How so?
Well, these internet service providers, ISPs, they had no real incentive to check content before it went live, only after a notification came in.
Reactive, not proactive.
Exactly. And they weren't even liable for the period when the infringement was actually happening or for overblocking.
Taking down perfectly lawful content just in case.
Precisely. Just to be safe.
And this led to some major problems, didn't it? Research shows there was widespread abuse of the system.
Yeah, definitely. We saw instances of false claims, even like outright extortion against YouTubers. People demanding money with the threat of a bogus copyright complaint.
I remember the Bungie lawsuit, the video game company. They sued someone for making false copyright accusations against legitimate fan content.
That's right. It really highlights how legitimate users could suddenly face account suspension, even termination, through these kind of three-strike systems.
Which raises serious concerns about fairness, proportionality, rule of law stuff.
Absolutely. And this systemic abuse really highlighted the need for reform. That's why the EU tried to tackle it with Article 17 of their Digital Single Market Directive, the DSM directive.
Right, the DSM directive. That requires platforms to use automated filtering, doesn't it?
It does. But even that has struggled with, well, how do you protect legitimate users using these filters? And now ISPs can actually be liable if they remove lawful content because their systems aren't precise enough.
So it's still a balancing act. Okay, so if we connect these lessons from Safe Harbor, that whole experience, to the current buzz around generative AI, we see the exact same tension emerging.
Absolutely. How do you protect copyright holders while still allowing this powerful new tech to develop quickly, especially when AI models need just vast amounts of training material?
And right shoulders are understandably deeply concerned that their material is being used for data mining to train these AI systems without their consent or any kind of license.
We're already seeing lawsuits, right? Authors suing OpenAI in the U.S., arguing their copyrighted works were used unfairly.
Exactly. And look at the UK. They initially proposed a very broad text and data mining exception for AI. It would have made it much easier for AI companies.
But they withdrew it.
They did, after significant public backlash from creators who felt their rights were just being ignored.
So the EU took a different approach.
Yeah. a different kind of compromise. Commercial text and data mining is generally allowed unless the copyright holder explicitly opts out.
But that sounds like a nightmare for creators.
Yeah.
Trying to opt out work by work, model by model.
It creates huge practical challenges, absolutely. Fragmented ownership, poor metadata. How do you even track it all?
So it raises the question, how radical do the solutions need to become?
Well, some French legislators have floated ideas like new rights for creators whose works contributed to AI output, or even like a tax system on AI companies to pay authors when you can't trace the exact source.
Wow. Okay. So from the digital frontier of AI, let's maybe broaden our lens a bit. How are privacy laws shaping this whole landscape?
They're proving absolutely pivotal in governing AI more broadly. Data protection authorities, the DPAs, they are really asserting their role globally.
We've seen some big enforcement actions.
Oh yeah, high-profile ones. The Dutch DPA hitting Clearview AI with a EUR 30.5 million fine. The Italian DPA fining OpenAI EUR 15 million. Even the Irish Data Protection Commission has active proceedings against X, formerly Twitter.
And it's not just Europe, right?
Not at all. Hong Kong has its AI model personal data framework. Singapore's issued guidelines. The UK's ICO, the Information Commissioner's Office, has its own generative AI guidance. It's happening everywhere.
Meanwhile, in the U.S., it's still, well, a patchwork.
Still a patchwork, yeah.
A growing number of state privacy laws. New ones coming into effect literally this month. Iowa, Delaware, New Hampshire, Nebraska, New Jersey.
And more later this year. Tennessee, Minnesota, Maryland.
All in the absence of a comprehensive federal law, which must make compliance incredibly complex for businesses operating across state lines.
It certainly creates headaches. And another major debate that's really heating up is around these consent or pay models.
Ah, right. Pay for privacy, essentially.
Kind of. Proponents argue, look, this is the internet's grand bargain, free services for personalized ads. If you don't want the ads, you pay a subscription.
But critics are worried about a privacy divide.
Exactly. A situation where only those who can afford it can actually opt out of having their data shared and used. Meta is even suing the European Data Protection Board, the EDPB, over their opinion on this.
While the UK ICO seems to be signaling a potentially different approach, it's messy.
Very messy. And then you have the whole issue of international data transfers hanging over everything.
After that massive EUR 1.2 billion fine for Meta and the suspension of its EU-US data transfers, you wonder if a Schrems 3 challenge is coming.
It's definitely a possibility. Another potential disruption to how global companies operate. Always something to watch.
It's interesting, though, you mentioned China.
Yeah, what's quite insightful there is that China has actually eased some of its cross-border data transfer requirements recently.
Really? Why?
Well, it looks like an attempt to balance data sovereignty, which is still important to them, with attracting foreign investment. Shows different countries are trying different approaches to this shared global challenge.
Ultimately, what we're seeing, it feels like, is that privacy laws are just one piece of a much bigger digital regulation puzzle.
That's exactly right. Companies are being forced to break down those internal silos. The privacy team, the cybersecurity team, the product team. They all need to talk to each other for a more holistic data governance approach.
Because it's not just privacy anymore.
No. You've got new cybersecurity laws like NIS2 for critical infrastructure, the Cyber Resilience Act for digital products, DORA for financial services. They're all active now. Companies are moving from theory to implementation.
And regulators are working together more.
Increasingly, yeah. Especially on consumer protection and antitrust. The argument being that healthy competition can actually lead to better privacy practices for consumers.
Plus, all those initiatives around data access, portability, reuse, like the EU's Data Governance Act and Data Act, trying to unlock data for innovation.
Which creates both opportunities and new compliance challenges for businesses. It's a truly multi-layered data law architecture they have to navigate now.
Yeah, it really highlights how diverse and interconnected the legal response to digital transformation is. It cuts across so many different fields.
Yeah, absolutely.
Okay, so building on that theme of law adapting to new forces, let's maybe pivot to a very different but equally massive global challenge. Climate change.
A huge one. And law is playing an increasingly crucial role there, too. Nearly 60 countries now have national climate framework laws.
Setting the strategic direction, the institutional arrangements.
Exactly. And a key takeaway from the sources here is how these laws drive change. Often through distinct channels of influence. Some are direct requirements in the law, others are more indirect impacts.
Okay, so let's dive into some of those core building blocks. Targets and carbon budgets seem absolutely crucial.
Definitely. Think about Ireland. They have 5 yearly carbon budgets, specific emission ceilings for different sectors.
Or New Zealand's unique split gas target for biogenic methane by 2050. That acknowledges agriculture's role.
Right. And Germany has specific targets for 2030, 2040, aiming for greenhouse gas neutrality by 2045, with annual budgets for each sector.
These things fundamentally define political accountability, don't they?
Yeah.
They create clear markers for progress or lack thereof.
Precisely. And beyond targets, you see requirements for robust planning and policy processes. Governments are mandated to create and update climate action plans.
Like Ireland's annual climate action plans or New Zealand's emissions reduction plans.
Yeah, and this encourages a whole-of-government approach, trying to improve that cross-sectoral coordination, make sure everyone's pulling in the same direction.
Another critical element seems to be public sector mandates and these new institutions, independent advisory bodies.
Like Ireland's Climate Change Advisory Council, the CX, or New Zealand's Climate Change Commission, the NZCCC, Germany's Council of Experts on Climate Change.
What's really insightful here, though, is the language. The precision of the legal wording matters hugely.
It really does. Ireland's law has this strong mandate requiring public bodies to act consistent with climate plans, and that's led to significant impacts.
Whereas weaker language in New Zealand and Germany.
It's limited the effects, and litigation has actually confirmed that. It shows that even critical climate goals can be, well, a bit toothless if they aren't backed by clear, enforceable mandates.
That's a fundamental insight into legislative design, isn't it? Not just a nuance.
Absolutely. Precision equals accountability. And finally, you have requirements for reporting, assessment, and review. These are critical for transparency.
Like Germany's projection report or New Zealand making the government respond to the Climate Commission's assessments.
Yeah.
Creates feedback loops.
Exactly. Keeps the pressure on and allows for adaptation.
But these laws also have indirect effects, right? Beyond the direct mandates written in the text.
Oh, absolutely. One interesting thing is they often lead to increased institutional capacity within government departments.
How so?
Well, having the law gives climate-focused units a stronger justification to ask for increased funding and resources. It helps the bureaucracy grow to actually meet the challenge.
That's a powerful indirect effect. And what about litigation? Can you actually enforce these laws in court?
Yes, increasingly. These framework laws provide a statutory hook, as they say, for judicial scrutiny. We've seen landmark cases.
Like Neubauer in Germany.
Neubauer and all of Germany, yeah, where citizens successfully sued their government for inadequate climate action. And Friends of the Irish Environment v. Ireland, Climate Case Ireland, which pushed for stronger national targets.
So courts can force legislative reforms.
They can. Litigation is a powerful tool for accountability, even if it's often a last resort.
And these laws must send signals to the broader economy, too, I imagine.
Definitely. Clear signals to the private sector, to subnational governments, about the direction of travel. This leads to alignment, even without direct mandates sometimes.
Like New Zealand making climate disclosures mandatory for corporations.
Exactly. Forcing businesses to report on their climate risks and impacts. That changes behavior.
Now, when it comes to the real-world impacts on society and, the climate itself, is it too early to tell?
It's often too early to see direct, large-scale impacts on emissions yet, but we are seeing initial shifts in financial flows and some positive social outcomes.
Like the just transition aspect.
Yeah, that's a compelling example. Ireland embedded just transition right into its climate law. This led to the National Just Transition Fund.
What did that do?
It committed over $22 million to support communities in their Midlands region, which was heavily impacted by the shift away from peat production. It funded new jobs, retraining.
So the law was used directly to address social equity during the transition, trying to make sure people weren't left behind.
Exactly. But not all laws land smoothly. Look at the German heating law.
Ah, yes, that caused a stir.
Huge public backlash. It aimed to speed up the shift to renewable heating, but there was really poor communication about the social impacts, the costs for homeowners.
It highlights how crucial clear public engagement is when you're making these kinds of big societal changes.
Absolutely. So when you look at all this, what stands out to you about how these laws are shaping economies and daily life? From energy choices to how cities are planned?
It's definitely moving beyond just abstract targets. It's becoming tangible. Okay, let's maybe zoom out a bit again and think about the even broader forces at play. We talked tech, we talked climate. What are just globalization itself? How is that unseen hand shaping the legal sphere?
It's a huge factor. We can define legal globalization as essentially the formation of a new global system of legal norms. International law, national law, the rules of international business, they're all becoming deeply interconnected.
And this happens in a few key ways.
Yeah. Sometimes it's formal legal integration, like states forming a common market with shared laws. Sometimes it's more about internationalization, countries adopting international standards or trying to harmonize their laws with others. Unification is the goal sometimes.
Or just implementing international rules directly into national law.
Right. And there are some really significant trends emerging from all this. A key one is the rise of what the sources call supranational legal arrays.
Meaning?
Legal bodies and systems that operate beyond national borders, beyond traditional state sovereignty. Think about international air law, international human rights law, and of course the really powerful example of European Union law.
And this leads to global or regional courts, too.
Exactly, like the International Court of Justice or the European Court of Human Rights. They enforce laws and rights that transcend individual nations.
We're also seeing law just
Right.
expanding, right?
Mhm.
Covering more and more ground.
An expansion and deepening of legal regulation, yeah. Law is reaching into entirely new areas of life and regulating existing ones much more comprehensively.
Like cybercrime.
Perfect example. The sheer scale of global cybercrime has forced countries to create new international agreements, new national laws, targeting digital offenses, an area that barely existed legally a few decades ago.
And new branches of law are popping up. Environmental law, tech law, energy law, medical law.
All developing rapidly in response to new challenges and, frankly, new scientific understanding.
This brings up an interesting, maybe slightly uncomfortable point from the sources. The politicization of law. Does politics sometimes just trump law?
Well, the sources suggest that law is increasingly used to mediate political relations, yes. And often when law and politics really collide, politics has prevailed.
It even suggests law can be used as a powerful offensive weapon to protect the interests of superpowers or big corporations.
It does raise that point. But on a more positive note, there's also a trend towards what's called the humanization of law.
Meaning incorporating human rights and values.
Exactly. Legal norms increasingly embodying principles of humanism, prioritizing human values and rights. Now, while this is seen as a universally recognized achievement in theory,
There's a but.
there's a but. In many countries, it's noted that this is often just proclaimed, enshrined in documents, but isn't fully realized in social practice.
And it can even be misused.
It can potentially be used by world centers of force as a reason for intervention in other countries, according to one perspective in the sources. So it's complex.
So clearly, it's not just a smooth, uniform march towards global legal integration. There's pushback.
Definitely. Globalization triggers counter processes, things like localization efforts to preserve traditional national legal forms. And glocalization.
Localization.
Yeah, that contradictory process of combining global standards with local adaptations. This whole push and pull shapes the diversity and integration of modern legal systems.
It creates this fascinating mosaic, doesn't it? Legal systems are kind of converging globally in some ways, but also holding on to unique national characteristics. Incredibly rich and complex.
Absolutely.
Okay, now let's bring it maybe closer to home for many of our listeners, especially if you're involved in business in the U.S. There's a significant shakeup happening right now in American administrative law.
Yeah, a really big one. The Supreme Court is actively reshaping the rules that govern federal agencies and all their regulations.
And at the center of this is a case called Chevron.
Chevron USA, Inc. v. Natural Resources Defense Council, Inc. from 1984, arguably the most cited case in administrative law.
So what did Chevron do, basically?
In simple terms, it established a principle of judicial deference. Courts would typically defer to a federal agency's reasonable interpretation of an ambiguous statute passed by Congress.
The idea being that agencies have the expertise.
Kind of. The thinking was Congress implicitly intended agencies with their specialized knowledge to fill in the gaps when a law wasn't perfectly clear.
But Chevron has faced a lot of criticism over the years.
Serious criticism, yeah. It raises serious separation of powers questions. Does it let the executive branch, where agencies sit, effectively make law, which is constitutionally Congress's job?
And critics also argue it might encourage agencies to be, what was the phrase, extremely aggressive in pushing their policy goals through ambiguous laws.
Right, squeezing policy into ill-fitting statutory authorizations.
And this isn't just academic debate anymore. The Supreme Court specifically took up the Chevron question in a new case, Loper Bright Enterprises v. Raimondo.
Yeah, that case involves commercial fishing vessels having to pay for federal observers on board. The fact the court agreed to specifically review the Chevron precedent itself.
Suggests they might be ready to kill Chevron outright.
That's the speculation. It's not just a minor tweak. It could be a seismic shift, potentially redefining the balance of power between courts and federal agencies.
And getting rid of Chevron would certainly fit with a growing skepticism, at least on the current court, towards government regulation.
It aligns with the court's recent reinvigoration of two other legal doctrines that also limit agency power.
Okay, what are those?
First, there's the major questions doctrine. This basically says agencies can't make decisions on huge, major questions with extraordinary economic and political significance unless Congress has clearly given them that specific authority.
We saw that in the West Virginia v. EPA case on climate regulation.
Exactly. And also in Biden v. Nebraska, the student loan relief case, the court said the agency lacked clear congressional authorization for such a major program.
Okay, that's one. What's the second doctrine?
The non-delegation doctrine. This is an older idea, but it's getting renewed attention. It ensures Congress doesn't improperly give away its core lawmaking power to other branches, especially agencies.
The court is essentially saying, Congress, if you want something big done, you need to legislate it clearly. Don't just hand off the details and the big decisions to an agency.
Pretty much. And alongside these doctrines, the court has also opened up new procedural routes for businesses.
How so?
They've made it easier in some cases for businesses to directly challenge agency actions in federal court, bypassing some of the usual, often lengthy administrative review processes. The Axon Enterprise case against the FTC is an example.
So, okay, let's connect this back to the listener. What does all this mean, especially if you're running a business or involved in a regulated industry?
Well, on one hand, these changes offer fresh opportunities to challenge regulations you might see as unfavorable or exceeding an agency's authority.
Like, for example, the SEC's proposed rules on climate change disclosures or cybersecurity reporting.
Potentially, yes. Businesses could challenge those under the major questions doctrine, arguing the SEC lacks clear congressional authority for such expansive rules.
But the sources say this is a double-edged sword.
It really is, because while challenging unwanted regulations might seem like a win, it also risks creating destabilizing effects. By undermining numerous long-standing regulatory regimes that businesses have actually come to rely on for predictability and a level playing field.
Can you give an example?
Sure. The U.S. Chamber of Commerce, usually critical of regulation, has actually defended certain Department of Homeland Security rules on foreign student visas, or even some EPA rules.
Why would they do that?
They argued that striking down these established rules would actually increase regulatory burdens and costs for businesses because the known system, even if imperfect, provides a predictable framework to operate within. Chaos isn't good for business either.
Right, so the administrative law landscape is shifting dramatically. It's creating both challenges and opportunities, and it definitely requires close monitoring for anyone affected by federal regulations.
No doubt about it.
Wow. We have covered a lot of ground today, from copyright fights over AI and that complex global dance of data privacy,
To the strategic impact of climate laws, and now this fundamental reshaping of administrative power in the U.S.
What really stands out, I think, is that the law, it's far from static, isn't it?
Right.
It's in this constant dynamic struggle to keep pace with a world that just keeps accelerating.
Absolutely. This deep dive really shows us that legal evolution isn't just about dry technical rules. It's about navigating these profound societal shifts driven by technology and globalization. It's about balancing established rights with this urgent need for progress.
The challenges are immense, and the outcomes, well, they're far from certain. But one thing seems clear. The journey of law in the 21st century is going to be anything but dull.
Definitely not dull. And maybe something for you, the listener, to consider is this. If the goal is to make law flexible enough to adapt to rapid change, how can we possibly ensure it still provides the stability, the predictability, and the protection of fundamental rights that we all rely on?
That's the crucial balancing act, isn't it? Something to think about.